Somewhere in the hill country of Western Virginia, inside a courthouse that remains standing to this day, there is a desk. Not a replica. Not a reconstruction. The original piece has been shifted 3 times over the decades, its surface scratched and stained, and marked by long silence. Local historians who have examined it describe a faint seam along the inner bottom drawer, nearly invisible unless you know exactly where to apply pressure. For nearly 60 years, no one pressed in the correct spot. And for 60 years, the Callaway family controlled every deed, every verdict, every boundary line in Harland County. They governed the roads Cole traveled. They governed the men who tallied votes. They governed, it was later said, the very ground beneath the feet of people unaware they were standing on stolen land. It took a dead man's concealed map, folded twice, wrapped in oilskin, and tucked inside a false bottom, built by a cabinet maker paid for his silence, to dismantle 60 years of legal fraud, so precise and so patiently executed that the circuit court examiner reportedly wept when he finally grasped what he was examining. This is that story. Before we proceed with the account of Judge Harland Callaway and the map that brought down his family's empire, if you've never encountered this history before, you're not alone. And that's no accident. Subscribe to this channel so you never miss a story like this one. Hit the notification bell and drop a comment telling us what state or city you're listening from. We want to know where in the country our listeners are finding us. Now, to grasp what that map signified, what it truly signified, you have to understand what Harlan County, Virginia, looked like in the winter of 1831. The county had been formally established less than 2 decades before the events of this narrative commence. Carved from older mountain territories as settlers pushed deeper into the Appalachian interior. It was not a prosperous region by the standards of the Virginia Tidewater or the plantation estates to the east. The terrain was steep and forested, laced with cold creeks that ran brown in autumn and bone pale in February. The men who first filed land claims there were surveyors, veterans of the war with Britain, small farmers moving west ahead of debt. Most of them registered parcels of 50 to 300 acres, subsistence plots with timber stands and creek, bottom fields barely wide enough to justify the word farm. But beneath that hill country lay coal, not the soft surface coal that could be scraped up with a hand tool, but seams of bituminous black running deep and consistent, the kind of deposits that by the 1840s and 1850s would make men extraordinarily wealthy. In 1831, most county residents had no clear sense of what lay under their land. They knew the black outcroppings along the creek banks. They burned it in their fireplaces during harsh winters. But the industrial implications, the furnaces, the railroads, the scale of extraction that would come, were not yet imaginable to men plowing ridgeline fields with single, share plows. Elias Callaway understood it. He had come to Harland County in 1819, not as a farmer, but as a land agent, carrying letters of reference from a Richmond law firm and a surveyor's certification that he may or may not have earned honestly. He was 31 years old, lean, well-spoken in the careful manner of men who have practiced their delivery in mirrors. He wore good boots. In a county where most men wore whatever leather they could stitch themselves, good boots meant something. He set up a small office in the county seat, Garfield's Crossing, a settlement of perhaps 400 souls, a mill, a tavern, 2 churches, and an unpainted courthouse that leaked in the spring rains. He offered to help settlers register their deeds properly, to survey disputed boundary lines, to file the correct paperwork with the county clerk. His rates were reasonable. His manner was reassuring. In the first years, his work appeared entirely legitimate. The records from that period, the ones that survived intact, show a surveyor filing measurements that matched physical landmarks. A land agent helping families navigate a bureaucratic process that most of them found confusing and slightly threatening. Several families from that early period, when later interviewed by circuit court investigators, remembered Elias Callaway with something approaching warmth. He had been patient. He had explained things in plain language. He had brought the paperwork to them rather than making them travel to the county seat. What those families did not know, what almost no one knew at the time, was that Elias had spent a significant portion of the previous 2 years traveling the hill country with a different purpose than the one he presented. Before he opened his Garfield's Crossing office, before he presented his letters of reference, he had walked every major ridge and creek bottom in the area, recording outcroppings, measuring seam exposures, keeping his own private ledger of where the coal lay thickest. He had paid, in several cases, small sums to local men to guide him to areas they described as having particularly heavy stone coal deposits. He had paid these men, to say nothing about the nature of his interest. By the time he opened his office, he already knew which land was worth owning. He knew it not from intuition or general geological knowledge, but from direct, careful observation. A private survey of the county's underground wealth conducted, before he had any official standing there, finished months before any of the people whose land he would shortly be manipulating had any idea who he was. This is the foundation on which everything else was built. The fraud was not opportunistic. It was designed. It was designed before it began by a man who understood what the land would be worth in 20 years, in 40 years, in a future that the people around him could not yet clearly see. And he was patient enough to wait for that future, while slowly, systematically, quietly taking from them what they did not yet know they had. By 1827, Elias Callaway was the county surveyor. By 1829, he was also informally, but effectively, the principal advisor to the county court. When the sitting judge, an elderly man named Obadiah Fenn, died of a lung ailment in the winter of 1830, the circuit appointments that followed placed Elias's older brother, Harland Callaway, in the vacated judicial seat. Harlon was a lawyer trained in Richmond, precise and cold and humorless. He wore his gray hair back in a style that had gone out of fashion in the cities 15 years earlier, which in Garfield's Crossing made him look distinguished. He believed genuinely, and without apparent irony, that his family's growing authority over the county was simply the natural ordering of capable men above lesser ones. Together, the Callaway brothers formed an arrangement that had no formal name and needed none. Elias surveyed the land. Harlon interpreted the law. Between them, they controlled what a parcel of ground was legally said to be, and what it was legally said to be worth. The families around them, the Comses, the Sargents, the Cornets, the Sloans, were hard-working people with deep roots and thin margins. Most of them were illiterate or semi-literate. Many had never seen the official surveys of their own land. When Elias Callaway appeared at a man's door in 1823 or 1824, carrying rolls of paper and speaking in the language of deeds and easements and boundary adjustments, most farmers did what people do when a confident man in good boots uses words they don't fully understand. They trusted him. They trusted him because he was helpful. They trusted him because he had been helpful to their neighbors. They trusted him because his brother was a judge and the county court was the closest thing to settled authority that the region had. The entire arrangement of society in Garfield's Crossing radiated outward from that courthouse. And it was very difficult for a man farming 80 acres and worrying about his children's winter to imagine that the courthouse itself was part of the problem. That trust would take decades to fully betray. And by the time it did, Elias was dead, and Harlon was deep in the most comfortable phase of his power, and the county had changed entirely around them. The man who first pulled at the thread that would unravel everything was not a lawyer, not a circuit court examiner, and not a crusading newspaper editor. He was a school teacher named Edmund Prader, 27 years old, recently arrived in Garfield's Crossing from a teaching position in Wise County, and he stumbled into the middle of it because of a dead woman's trunk. In the autumn of 1857, a widow named Lucinda Combs died at the age of 73 on a farm she had worked alone since her husband Cornelius Combs had passed 14 years earlier. She had no surviving children. Her nearest living relative was a nephew, Thomas Combs, who had moved to Kentucky as a young man and made his way as a carpenter's apprentice, and later as a journeyman builder. When word reached him in October that his aunt had died, and that there appeared to be some dispute about the farm's ownership, Thomas Combs made the journey back to Harland County. He arrived in early November to find that the farm, 112 acres of creek bottom, and timber registered in Cornelius Combs's name in 1818, had already been claimed by the Callaway Land Company in a debt proceeding that Thomas had never heard of, that Lucinda had apparently never understood, and that had been filed and adjudicated with remarkable speed in the weeks immediately following her death. It should have ended there. It ended there for many families. A man without money for a lawyer, without influence, without the kind of name that opened courthouse doors. He came. He looked at the papers. He was told the proceeding was lawful, and he went away. Thomas Combs almost did the same. But before he left the county, he stopped at the schoolhouse where Edmund Prader had recently taken the teaching post, because Prader boarded with a distant Combs relation, and Thomas needed a place to sleep before his return journey. The two men talked. It was the kind of conversation that happens in the cold, in a small room with a fire, between a man who has just lost something and a younger man who is still idealistic enough to be genuinely angry on his behalf. Prader had only been in Garfield's Crossing a few months, but he had already noticed things. The way the land records at the courthouse were organized, or rather disorganized, the way certain deed books had pages that appeared to be out of sequence, the way the current county surveyor, a man named Aldous Pickett, who operated under Harland Callaway's direct patronage, filed surveys that were difficult to reconcile with the physical landmarks described in older documents. Prader was not a lawyer. He was a school teacher who had grown up helping his father, a small county clerk in Wise County, organize legal filings. He knew what properly kept land records looked like, and what he had seen in the Harland County courthouse in his first weeks there had made him uneasy in a way he could not yet articulate. Thomas Combs showed him the debt proceeding papers. Prader read them twice. Then he asked if Thomas still had his aunt's papers, her original documents, anything her husband might have left. Thomas had one thing, a trunk. He had brought it with him from the farm before the Callaway Company's men arrived to take possession of the property. It was Lucinda's keeping trunk, the kind of flat cedar, lined box that rural families used to store documents, correspondence, and valuables. Inside it was the usual accumulation of a long life, a Bible with family names written in the front pages, a small amount of paper currency that had lost most of its value, letters, and folded at the very bottom under a piece of cotton batting, a hand-drawn map. The map was old. It had been drawn on heavy paper that had yellowed to the color of old cream, and it showed a section of creek bottom and ridgeland in what was clearly Harland County terrain, though none of the official names were used. The boundary markers were trees and rock outcroppings and a particular bend in the creek that Prader would later find described identically in the 1818 deed registration. In the corners of the map, there were measurements, hand-calculated distances, bearing angles, the kind of notation a surveyor would make in the field, and in the lower right corner, in a clear, careful hand, were 2 lines of text. The first line read, "Surveyed and confirmed, October 14, 1818. Cornelius Combs, grantee." The second line read, "E. Callaway, county surveyor." Prader stared at that for a long time. Then he carried the map to the window and held it up to the thin November light, and saw what he had not seen before a second sheet, almost translucent, pressed flat against the back of the first, and attached to it along one edge. This second sheet was covered in notations in the same hand, measurements, calculations, and along one margin, a column of numbers followed by initials. The initials appeared 7 times HC, Harland Callaway. Prader sat down on Thomas Combs's borrowed cot and did not speak for several minutes. What the second sheet appeared to show, what he would spend the next 4 months working to confirm, was a private accounting of adjusted survey figures, the official measurements that appeared in the public deed books, and alongside them, the actual field measurements from which those official numbers had been derived. In every case where the 2 figures diverged, the adjustment ran in the same direction. It subtracted acreage from the registered parcel, acreage that then appeared without explanation in Callaway Land Company filings in subsequent years. It was not proof, not yet. A hand-drawn map in a widow's trunk with numbers in the margin proved nothing in a court of law. But it was a window into a mechanism. And now that Prader had seen the mechanism, he could not stop seeing it. The winter of 1857 into 1858 was one of the coldest that Western Virginia had seen in a generation. The creeks froze hard enough for cattle to cross on the ice, and the ridge roads became impassable for weeks at a time. It was, in a strange way, the right season for what Prader was doing, because the isolation forced a kind of methodical patience that the work required. He could not travel. He could not easily be observed. He sat in his room above the schoolhouse night after night with candles and the courthouse documents he had spent months quietly borrowing, reading, and returning before anyone noted their absence. He had help, though he was careful about it. The circuit court in Garfield's Crossing employed a filing clerk named James Arden, a slight man in his 40s, who had worked in the courthouse for nearly 20 years, and who had developed over those 2 decades a comprehensive and repressed horror at what he saw moving through the land record books. Arden had said nothing for 20 years because he had a wife and 3 children, and because Harland Callaway was still, in the winter of 1857, a sitting judge. But Arden was the kind of man who kept things. Not by design, he was not calculating, but by nature. He remembered which filings had come in together. He remembered when entries that appeared sequential in the deed books had actually been filed weeks or months apart. He remembered the surveyors who had come to the courthouse over the years with papers that even to his non-legal eye looked wrong. Arden was also a man who had learned over 2 decades of proximity to power. He could not contest a very specific kind of silence. He did not refuse to speak to Prader. He was too careful for outright refusal, which might itself have been noticed. Instead, he spoke in the manner of a man who is sharing observations about the weather while describing a catastrophe. He would mention a date. He would mention a sequence. He would describe a physical characteristic of a document without quite explaining what that characteristic implied. And Prader, who was quick and who had been trained by his father to notice the structure of records, would listen and understand and ask no follow-up A question that might force Arden to commit to anything explicit. It was between them a kind of elaborate dance. Not dishonest, but not quite honest either. Conducted in the narrow space between what a frightened man would say and what a careful young man needed to hear. 2 decades of fear had made Arden fluent in implication. And those 2 decades may have been exactly what the situation required. Because a bolder man would have pushed further, would have forced confrontations that would have attracted attention. And this particular fraud required, above all, patience and invisibility to dismantle. He remembered specifically a cabinet maker. His name was Josiah Trent, and he had come through Garfield's Crossing in the spring of 1836, hired by Elias Callaway to do some work on the courthouse furniture. A commission that had struck Arden as unusual at the time, because the courthouse furniture was county property, and the county should have arranged that work, not the Callaways. Trent had spent 3 days in the courthouse, working mostly in Judge Harland Callaway's private office. When he left, the desk looked exactly as it had before, as far as Arden could tell. Whatever Trent had done was not visible. He had been a quiet man, Arden remembered, not unfriendly. He had eaten his noon meal in the records room, and they had exchanged pleasantries about the weather and the state of the roads, but contained the kind of quiet that comes from knowing something and deciding not to share it. And he had not asked any questions about the courthouse or the Callaways or the work he was doing. He had come, done the work, taken his payment, and gone. And Arden had watched him leave, and had a feeling he could not name at the time. Something between unease and the sense of having missed the point of something important. He had been right, but it had taken him 21 years to say it to anyone. Trent had died in 1849, but his grandson still lived in the county, a young man named Willis Trent, who worked at the mill. Arden told Prader about the cabinet maker in February of 1858, on a day when the road outside the courthouse was frozen solid, and the 2 men were the only people in the building. He said it quietly, as if someone might hear through the walls. He said he didn't know if it meant anything. He said he just remembered it. Prader visited Willis Trent at the mill the following week. Willis was cautious at first. There was no reason to trust a school teacher he had barely met, and the Callaway name still carried enough weight in the county to make careful men careful. He said his grandfather had been a good craftsman who had kept to himself and never caused any trouble. He said he didn't know much about his grandfather's work. He said this in the way that people say things they have decided to say, rather than the way people say things that happen to be true. On Prader's second visit, he brought the map from Lucinda Combs's trunk. He did not explain it at length. He set it on the workbench beside Willis and watched the young man look at it. Willis was quiet for a long time. Then he traced one edge of the map with his finger, not touching it, just tracing the air above it, and said something had been bothering him since he was a boy. He said his grandfather had described the courthouse job to him once late in life, in the way that old men sometimes describe things they have felt guilty about without ever confessing to. He said his grandfather had built something into the desk, a false bottom, in the lower right drawer, with a spring release mechanism. He said a man had paid him to do it, and had told him specifically to tell no one, and had given him more money than the work was worth by a significant amount, which his grandfather had recognized as the price of his silence rather than the price of his craft. His grandfather had told Willis because he was dying and because he said a man should not take certain things to his grave without telling someone. Prader asked what his grandfather thought the compartment was for. Willis said he didn't know. His grandfather hadn't known. He had guessed it was for valuables, money, letters. Something a man wanted hidden from his household. He had not guessed, or had not said he guessed, that it might be something the law would want to know about. Either he had not made that connection, or he had made it and had chosen for 20 years to say nothing. By the time he told Willis, it had been 13 years since his grandfather had done the work. Whatever was inside the desk, if anything was inside the desk, had been there for 13 years. That had been in 1849. The desk had sat in the judge's chambers for another 8 years before Edmund Prader walked into Garfield's Crossing and had the particular combination of intelligence, stubbornness, and righteous anger that made him the right person to hear what Willis Trent had to say. Prader thanked him and walked back to the schoolhouse through the February cold. And that night he wrote in the small notebook he had started keeping, "There is something inside the desk. The question is whether it is still there after 22 years. The question after that is whether I will ever be in a position to find out." Getting inside the courthouse, after hours without authorization, was not something a county school teacher could do without serious risk. Prader understood this clearly. He was not a reckless man. He was methodical and aware of his own vulnerability. He had no legal standing. He had no official relationship with the court. What he had was a trunk full of documents that suggested fraud, a filing clerk who was afraid to be seen in public talking to him, and the name of a dead cabinet maker. Through February and into the first thaw of March, Prader continued his careful work at the courthouse, visiting only in ordinary daylight hours, requesting only the documents that a citizen had legitimate reason to request: deed book indices, county plat records, the public-facing survey logs. He was building what he thought of as the visible architecture of the argument. What could be proven without the map in the desk if it turned out the map was gone or had never been there, or had been retrieved by someone in the 22 years since Elias Callaway died? The visible architecture was not nothing. He could demonstrate through the deed records alone that parcels adjacent to Callaway holdings had a pattern of acreage reduction at moments of transfer. Small adjustments. 2 or 3 acres here, 5 there. The kind of thing that looked like rounding error until you mapped it across 40 years and noticed that the rounding always ran the same direction, always against the smaller landholder, always in favor of the name Callaway appearing somewhere in the subsequent chain. It was not proof. A defense lawyer would call it coincidence. But it was a pattern. And patterns, Prader had come to believe, were the thing that liars found hardest to erase completely, because liars who are meticulous enough to erase every individual instance of fraud are rarely meticulous enough to examine what the instances look like assembled together. But he also found something he had not expected: a second generation of the mechanism. The original scheme, as far as he could reconstruct it, had belonged entirely to Elias Callaway, his surveys, his adjustments, his private accounting. But Elias had died in 1851, and the pattern in the deed books did not stop in 1851. It continued in slightly different form into the mid-1850s. The acreage adjustments became less frequent but larger. The debt proceedings, manufactured debts assigned to landowners who could not adequately challenge them in a court, where Harland Callaway sat as judge, became the primary instrument in the later period. The survey fraud had been Elias's method. The judicial fraud was Harlan's continuation of it, adapted to the tools at his disposal once his brother was no longer alive to survey the land himself. This was the thing that made Prader feel something beyond intellectual interest. Something colder, more visceral when he thought about it late at night. Elias had built the system. Harlon had inherited it and run it for the better part of a decade. not as his brother's scheme, but as his own, perfected and expanded. The two brothers had apparently never needed to discuss any of this openly. It had passed between them the way certain kinds of knowledge pass in families, through observation, through participation, through the gradual recognition that you are the heir to something that has no legitimate name. Arden confirmed this cautiously in one of their brief conversations. He said that in the years after Elias died, the complaints he sometimes heard from landowners about debts they didn't remember incurring, about judgment proceedings that moved faster than anyone expected, had a different texture than the earlier ones. Earlier complaints had been about surveys that didn't look right, about boundary lines that had moved between one filing and the next. Later complaints were about the court itself proceedings that seemed to resolve before any meaningful defense could be mounted. Witnesses who were somehow unavailable on the day they were supposed to appear, documents that were entered into evidence, and then, when people tried to reference them later, were difficult to locate in the record. Harland Callaway had been using the bench, not clumsily, not in the way that gets noticed immediately, but in the way that a man who has presided over a court for 25 years knows how to use it through timing, through procedural maneuver, through the power to decide which arguments were material and which were not, which witnesses' testimony was credible and which was not, which debts were properly documented and which were not. A judge who decides all those things in a county where no one has the resources to appeal to a distant circuit court has enormous power over the direction of money and land. And Harland Callaway had exercised that power with the same patience and precision that his brother had applied to the survey books. The break came, as it often does, not from cleverness, but from coincidence working in the right direction for once. In March of 1858, Harland Callaway, who was by then 69 years old, heavier than he had been, and suffering from a kidney ailment that his physician kept treating ineffectively, was required to travel to Richmond for a circuit court proceeding that could not be postponed. He would be gone for at least 10 days. His son, Randolph Callaway, who had taken over most of the active management of the family's land operations, traveled with him. The courthouse was not empty. The county clerk, a man named Ferris Dawn, who was loyally aligned with the Callaways, kept regular hours. But the judge's private office was locked, as it always was when Harlan was away. And Arden had his own work and his own habits, and was not inclined to spend his evenings in an empty building. Arden had a key, not to the judge's office specifically. That key lived on Harlan's person or in a locked drawer in Dawn's desk, but to the building itself and to the records room adjacent to the judge's chambers. The door between the records room and the chambers was interior, older than the lock on the exterior office door, and it had a catch mechanism that Arden had noticed over 20 years of working beside it did not fully seat when the temperature dropped below a certain point. It was still cold in March, cold enough. Arden had not agreed to do this. He and Prader had not had any explicit conversation about entering the chambers. But on the evening of March 11, 1858, Arden simply did not lock the records room behind him when he left the courthouse at his normal hour. He walked home. He said nothing. He sat up later than usual that night, and his wife later recalled that he seemed to have difficulty breathing normally. Prader entered the courthouse at 1100. He used a lantern with the shutter mostly closed, no more light than he needed to avoid the furniture. The records room door was unlocked. The interior door to the chambers required only the kind of upward pressure that Arden had described to him once in passing, in a sentence that had not been advice so much as observation. The office was cold and smelled of pipe, tobacco, and old paper. The desk was large. Walnut, topped, the kind of piece that had been expensive when new and had only grown more imposing with age. Prader set his lantern on the floor and opened the lower right drawer. It was full of papers, correspondence, mostly the ordinary accumulation of a judge's office life. He removed the papers carefully, setting them in order on the floor beside him, and ran his hands along the inside of the drawer. The wood was smooth and well fitted. He pressed along the seam at the bottom, working methodically from left to right. At the far right corner, the wood gave slightly, not a collapse, a controlled yielding, like a key engaging a mechanism. He pressed again, more firmly, and heard a soft click. The bottom of the drawer lifted along a concealed hinge. Beneath it, in a space no more than 2 inches deep, was a folded document wrapped in oilskin. He took it. He replaced the false bottom. He replaced the papers in exactly the order he had removed them. He left the chambers, left the records room, pulled the interior door to without latching it, walked out of the courthouse, and went directly to his room, where he sat with the lantern turned up fully, and unfolded what he had found. It was a map larger than the one from Lucinda Combs's trunk, nearly the full width of the desk when unfolded, and far more detailed. It showed the entire county, or rather the county as it had been organized in the late 1810s and 1820s. Every registered land parcel was drawn in with its listed acreage, and over the official parcels, drawn in a different ink, were the corrected measurements, the real boundaries, the true acreage, the actual ground that each parcel covered. The divergences were systematic. In every case where corrected measurements were marked, the original parcel had been reduced in the official record, and in every case where that reduction had occurred, the missing acreage had been absorbed into an adjacent parcel, always eventually a Callaway holding. The map covered more than 40 years of transfers. It was, Prader understood, both a record and a working document. Something kept not out of guilt, but out of necessity. A master reference that allowed the scheme to remain internally consistent, that prevented the false surveys from contradicting each other in ways that might have been visible even to an inattentive eye. It was meticulous. It was comprehensive. It was the work of a man who had understood from the beginning that large frauds require more discipline than honest work. Not less. At the bottom of the map, in the same careful hand as the notation on the Combs document, was a date, March 1836, the month and year that Josiah Trent, the cabinet maker, had built the false bottom. Elias Callaway had hidden his own master map inside his brother's desk 22 years before Prader found it. He had died in 1851 without apparently having retrieved it. What Prader did next was not what a reckless man would have done. He did not go directly to the county clerk. He did not confront Randolph Callaway when the family returned from Richmond. He did not publish anything or tell anyone beyond Arden and Thomas Combs, who was still in the county waiting. He made copies, 2 complete copies of the map drawn by his own hand over 4 nights in March. Referenced against the original Combs survey and the deed book records he had been studying for months. He wrote a formal account, 23 pages in his schoolteacher's precise hand, explaining the methodology of the fraud and identifying as specifically he could the parcels affected and the families who had originally owned them. He then wrote a letter to a lawyer in Abingdon, in Washington County, a man named Jervis Sutton, who had a regional reputation for taking difficult cases involving land fraud, the kind of cases that most county lawyers declined, because the opponents had money and the plaintiffs didn't. Sutton received the letter at the end of March. He wrote back in 2 weeks, cautious but interested. He said if the documentation was what Prader described, It was the most systematically organized case of survey fraud he had encountered in 30 years of practice. This was the moment when the situation became dangerous. Prader had assumed that the risk was confined to the period before he found the map. That finding it was the hard part. And that once found, the truth would carry its own momentum. He was wrong. A truth locked in a desk is inert. A truth moving through the hands of lawyers and circuit court examiners. That is a threat, and threats provoke responses. He did not know how Randolph Callaway learned that something was happening. He suspected Ferris Don, the county clerk, who noticed things. He suspected that Arden, under pressure, had said something he hadn't meant to say. He never determined the exact mechanism. What he did know was that the Callaway network in the county was not simply a family. It was an ecology. 23 merchants, mill operators, innkeepers, and tradesmen in Garfield's Crossing and the surrounding settlements depended on Callaway patronage in one form or another. Contracts for county work, favorable terms on loans arranged through Callaway connections, preferential treatment in the small disputes that landowners brought to the county court year after year. These men were not co-conspirators. Most of them had no idea what the Callaway land operation actually consisted of. But they were attentive in the way that people who depend on powerful families are always attentive to signs that the family's power might be under threat. And an out of county school teacher spending evenings at the courthouse, requesting old deed books, meeting quietly with a carpenter from Kentucky and a terrified filing clerk. That was the kind of thing that observant men noticed and mentioned to other observant men, without quite understanding what they were passing along. In early May of 1858, two things happened within the same week. First, Prader's room above the schoolhouse was searched. He knew because he had left small indicators, a thread across a drawer, a book placed at an angle, the kind of thing a man does when he has become careful. The search had been thorough. Whoever had done it knew what they were looking for. They had not found the copies of the map, which Prader had stored in the schoolhouse's cellar behind a loose stone, not in his room. They had not found his written account. But they had found his notebooks, and they had read them. And they had left them. An act of confidence, or threat, or both. The notebooks contained observations and questions, calculations and cross-references, but no conclusions explicit enough to be incriminating on their own. Whoever had read them would understand that Prader was building something. They would not yet know how far along it was. Second, Thomas Combs was approached on the road between Garfield's Crossing and his boarding house by two men he did not recognize, who told him that his aunt's debt had been an honest proceeding, that the farm was lawfully Callaway property, and that continuing to pursue the matter would be bad for everyone involved, especially people from out of the county who didn't understand local arrangements. Thomas was a large man and not easily frightened, but he was alone on a road in a county where the judge and the county surveyor shared a name, and he understood what he was being told. The men were polite. That was the worst part of it, he said later. They had been entirely polite, which meant they were certain they did not need to be otherwise. He came to Prader that evening. They sat in the cold schoolhouse. Prader would not take him to his room, not after the search, and spoke quietly for 2 hours. Prader told Thomas the full situation, for the first time the map, the copies, the letter to Sutton, the way the mechanism had worked across 4 decades. He also told him something he had not told anyone yet, that in examining the map the previous week, he had noticed something he had initially dismissed as a marking error. Along the eastern boundary of the county, in a section that had been sparsely settled in the early years, There were 4 parcels marked with a small symbol he had not seen elsewhere on the map. A double crosshatch. The kind of notation a surveyor might use privately without explaining it. He had spent several evenings trying to match those 4 parcels to the deed books and had found that all 4 were currently listed as unregistered public land. But in the early deed records, before a particular series of filings in 1831, they had been registered to 4 different families, all with the same surname Harp. He had found no Harp family anywhere in the current county, no Harp descendants, no forwarding records of sale or transfer. 4 parcels, roughly 300 acres combined, that had existed in 1830 and did not exist as private property in 1832, absorbed into the county's unregistered land stock through a process that Prader could not trace in the surviving records, because the relevant pages of the deed book covering that period were missing. Not damaged, missing. The binding holes showed where pages had been cut free. Thomas asked what had happened to the Harp family. Prader said he did not know. He had found no record of them leaving the county, no record of sale, no record of any legal proceeding. They had simply ceased to appear in any county document after the spring of 1831. The schoolhouse was very quiet for a moment. Outside, the May evening was cooling quickly, the way mountain evenings did even in late spring. Thomas said, "Then we need to get out of this county before we send anything." He was right. They left Garfield's Crossing on a Monday morning in mid-May, separately 3 hours apart, both claiming ordinary errands in neighboring towns. Prader carried the copies of the map and his written account inside the lining of his coat. Thomas Combs carried the original map from the courthouse desk, which Prader had never returned. A decision he had made without fully deciding, the same way people sometimes make the most consequential choices of their lives. What happened to the 4 Harp family parcels and to the 4 Harp families themselves was never resolved by the proceeding that followed. Sutton included it in his filing as an area of concern. Pemberton, the circuit examiner, noted in his report that the missing deed book pages and the disappearance of the 4 parcels from the record represented a pattern consistent with the broader fraud, but that the absence of surviving documentation made any specific finding impossible. He recommended further investigation. No further investigation was formally conducted. Whether the Harps had been bought out, frightened out, or something worse, the record does not say. The record stops at the edge of a question that nobody in the end pressed hard enough to answer. That, too, is a kind of verdict. Jervis Sutton met them in Abingdon on the evening of May 19, 1858, in the back room of a tavern, where he said he had conducted more honest legal business than in any courthouse he had ever entered. He spread Prader's materials on the table and examined them for 2 hours, asking questions that were precise and technical, and that Prader answered as accurately as he could. Sutton was a small man, thin-haired, with reading spectacles that he kept taking off and putting back on. He had the manner of someone who had been disappointed by evidence many times and had learned to check carefully before committing to anything. At the end of the 2 hours, he said, "The map is the key. The map from the desk. Without it, this is a circumstantial argument, strong but contestable. With it, and with the cabinet maker's testimony." "The cabinet maker is dead," Prader said. "His grandson. He'll say what he told me. I don't know if he'll say it in a courtroom." Sutton was quiet for a moment. "The handwriting on the map matches the surveyor's signature on the Combs deed. I can get that comparison done in Richmond by someone credible. If the handwriting is confirmed, then the map's origin is established. It's Elias Callaway's document, kept in Harland Callaway's desk, hidden there specifically. That's conspiracy, not accident." He looked at Thomas Combs. The original deed for your family's land was properly registered. The debt proceeding was filed after your aunt died. The question is whether the debt was real or manufactured. Were there any records among her papers? Thomas said there were letters. Some of them were from a man he didn't recognize, referencing an account that Lucinda had told him in the last years of her life. She knew nothing about, Sutton said. There it is. He then looked at the portion of Prader's written account describing the Harp parcels, the 4 properties that had vanished from the deed books in 1831. The families who left no forward trace. He read it twice. He asked Prader to confirm that the relevant deed book pages were physically missing, not merely illegible. Prader confirmed it. Sutton set that section of the account aside separately from the rest and said he wanted to think carefully about how to present it. The survey fraud is conclusive. The Harp matter, he said, is either nothing, a family that sold quietly and the paperwork was lost, or it is something considerably worse. Time is short. If we press it in the filing, we risk the court treating it as speculation and allowing the defense to use it to undermine the credibility of everything else. If we leave it out, we allow something potentially very serious to remain unexamined. He thought about it for 3 days. In the end, he included it not as a central claim, but as a documented anomaly requiring investigation. A question embedded in the filing rather than an accusation. It was, Prader later wrote, the most careful piece of legal judgment he had ever witnessed, a man deciding, in full awareness of what he might be describing, to name the shape of something he could not fully see. The filing went to the Circuit Court in Richmond in July of 1858. Sutton was meticulous about the choice of venue. He did not trust any jurisdiction where the Callaways had influence. And he was correct to be cautious, because when word reached Garfield's Crossing of what had been filed, the response from Randolph Callaway was immediate and forceful. He retained 2 lawyers from Lynchburg and filed a counter petition arguing that the map was a forgery, that Prader had fabricated or altered the document to support a fraudulent claim, and that the entire proceeding was an attempt by outsiders to unsettle lawful property rights, established over 40 years. The language of the counter petition was careful and confident and framed Prader specifically as the wrongdoer, a young man with no roots in the county, no stake in its welfare, motivated by unclear grievances. It was a strategy that had worked before in other courtrooms against other accusers. The powerful have always understood that the most effective defense against being accused of fraud is to accuse your accuser in return, and to do it in language formal enough that the accusation feels like the real proceeding. But Sutton had anticipated it. He had spent the 2 months between the filing and the first Richmond hearing locating additional evidence that Prader had not found a second surveyor, active in the county in the early 1840s, who had filed a formal complaint with the county court in 1843 about discrepancies in the official deed books. The complaint had been received by the court, docketed, and then somehow never acted upon. The docketing entry still existed in the Richmond Circuit records. The original complaint document was missing, but the docketing entry proved it had existed, which meant someone had caused it to disappear after it was received. Sutton also located the second surveyor himself. He was an elderly man by 1858, living in Tennessee, and he had left Harland County abruptly in the autumn of 1843 under circumstances he had never publicly explained. He was unwilling at first to travel to Richmond or to make any statement. He said he had put it behind him. He said he was old. He said it was a long time ago. Sutton traveled to Tennessee in June of 1858 and spent 2 days with him. Whatever was said in those 2 days was not recorded. But the old surveyor agreed to provide a written affidavit, notarized in Tennessee, describing what he had found in the Harland County deed books in 1843, what he had filed, and what had happened to him in the weeks after his complaint was received. Which included, he said, a visit from two men who arrived unannounced at his rented room in Garfield's Crossing and told him very quietly that it would be better for his family if he found work in another county. He had found work in another county. He had found work in Tennessee, and he had not spoken about any of it for 15 years. His affidavit was entered into evidence. The circuit examiner assigned to the case was a man named George Pemberton, 52 years old, with a reputation for thorough and unsentimental work. He took the map, the comparative surveys, Sutton's handwriting analysis, the docketing entry for the vanished complaint, the surveyor's affidavit, and the com's deed materials. He spent 6 weeks examining them in a room in the Richmond courthouse. His report, filed in September 1858, was 41 pages long. It confirmed the handwriting match. It confirmed the systematic divergence between official survey records and the corrected measurements on the map. It found that the 1843 complaint had been received and docketed by a court clerk whose appointment had been arranged through the Callaway family's Richmond connections. A clerk who had left the position in 1844 and could not be located. It found that the debt proceeding against Lucinda Combs's estate referenced an account with no documentary basis in any institution in the region. Pemberton's conclusion, in the measured language of legal examinations, was that the evidence supported a finding of systematic survey fraud extending from approximately 1820 to at least 1851, involving the deliberate manipulation of official land records, the corruption of at least one court filing process, and the enrichment of the Callaway family through the unlawful absorption of land belonging to at least 31 identified parcels. Regarding the Harp matter, Pemberton wrote a single paragraph. He noted that the missing pages, the absence of any documentary record of the four families after 1831, and the pattern of the surrounding entries were consistent with the broader fraud and warranted formal investigation. He recommended that the Virginia Attorney General's office take up the question independently of the current proceeding. Whether that recommendation was ever formally acted upon, the surviving record does not clearly show. When the report was read in open court in Richmond in October of 1858, Harland Callaway was present. He was 70 years old by then, still straight-backed, still wearing his hair in the old style. He sat beside his lawyers, and he did not change expression as the examiner's findings were entered into the record. He did not speak, and he had not spoken publicly about the case at any point. His lawyers had spoken extensively, skillfully, and without success. His son, Randolph, seated beside him, was not as controlled. Witnesses later described him as pale, then flushed, then pale again as the 41 pages progressed. At one point, he leaned toward one of the lawyers and said something that the lawyer immediately shook his head at. Whatever Randolph wanted to do in that moment, the lawyer prevented it. After the reading, Harlon Callaway rose, said he wished to reserve the right to respond in full at the appropriate proceeding, and walked out of the courthouse with a steadiness that some observers found more unsettling than any other possible reaction. He died 4 months later, in February of 1859, of the kidney ailment that had been worsening for 2 years. He died in his house in Garfield's Crossing, in the same county he had controlled for nearly 3 decades, having never been formally convicted of anything. Whether he died knowing what was coming for his family and chose to leave before it arrived, or simply died because sick men died, was never determined. The timing was what it was. The legal proceedings that followed Harland Callaway's death took 4 years to resolve. An eternity for the family's waiting, a reasonable pace for the scale of what was being untangled. Harland Callaway fought every step, as men in his position always do, because the alternative was to stop fighting and accept what was coming. He had inherited the legal challenge along with everything else. In the end, the Virginia courts ordered the reversion of 23 of the 31 identified parcels to the original registered families or their documented heirs. 8 parcels could not be fully restored because the chains of subsequent sale were too complex to unwind without creating new injustices. For those, the court ordered monetary compensation from the Callaway estate. Compensation that reduced the family's remaining holdings significantly, though not to nothing. The Callaway Land Company was dissolved by court order in 1862. The family did not disappear. Randolph eventually settled what debts he could, sold most of what remained to outside investors, and lived out the rest of his life in considerably reduced circumstances in a house in Abingdon. His children moved away by the 1880s, and the Callaway name in Harland County meant nothing in particular to the people who had grown up after the proceedings. Edmund Prader did not return to Garfield's Crossing after leaving in May of 1858. He stayed in Abingdon, working first as a clerk for Jervis Sutton, then studying law under his guidance, eventually being admitted to the Virginia bar in 1864. He practiced in Washington County for the rest of his working life, specializing, as Sutton had before him, in land title disputes. James Arden, the courthouse filing clerk, remained in his position through the entire proceeding. He was questioned extensively. He confirmed what he knew and nothing beyond it. After the Callaway proceedings concluded, he continued to work as the county's filing clerk until his retirement in 1871. He never made a public statement about any of it. He did, however, keep careful and impeccable records for the rest of his career. Records that later historians noted were the most precisely maintained in the county's history. Thomas Combs's farm was among the 23 parcels restored. He returned to the land in 1863 and worked it until coal interests began buying heavily in the region in the late 1870s. He sold then, knowing what the land was worth, knowing finally what it had always been worth. He had not been cheated of that knowledge a second time. Willis Trent, the mill worker and cabinet maker's grandson, did testify in the Richmond proceeding. He said what his grandfather had told him. He said it clearly and without embellishment. He was cross-examined for most of an afternoon by Randolph Callaway's lawyers, who tried every approach available to them to undermine the account of a dead man told through a living one. Willis held he was not a complicated witness. He had simply repeated what he knew to be true, and the honest repetition of a true thing is not easily broken by lawyers, even skilled ones. The desk remained in the courthouse. The false bottom was demonstrated to the court examiner during an in-person inspection in November of 1858, with Sutton, Pemberton, and representatives of both sides present. The spring mechanism functioned exactly as Willis Trent had described. The examiner noted in his report that the woodwork was of high quality, precise joinery, well concealed. The kind of craftsmanship that, in different circumstances, would have been a credit to the man who made it. Josiah Trent, Pemberton noted, had clearly been a skilled craftsman. He had been paid to hide something that should never have existed. He had told his grandson. His grandson had told a school teacher. The school teacher had pressed in the right corner of the drawer. That is the whole chain of it. A fraud that consumed 40 years. Brought down by a cedar trunk, a window in February, and an old man who couldn't take a secret to his grave without first telling someone. Just when we thought we'd seen it all, the horror in Garfield's Crossing intensifies. If this story is giving you chills, share this video with a friend who loves dark mysteries. Hit that like button to support our content. And don't forget to subscribe to never miss stories like this. Let's discover together what happens next. And there is a question that people who encounter this story often find themselves returning to. Not about the law, not about what was recovered or what was not, but about Elias Callaway himself, about the man who built the mechanism in the first place. He had the map made in 1836 at the height of his power, and he hid it inside his brother's desk. He could have destroyed it. There was no reason, from a purely self-protective standpoint, to preserve a complete record of his own fraud. The map was only useful if you needed to keep track of the scheme's internal consistency. If you needed to make sure the false numbers didn't contradict each other. After a certain point, once the surveying work was largely done, that function was finished. And yet he kept it, had it hidden carefully by a skilled craftsman, as if the documentation itself had become something he could not let go of. A record of what he had built, even if what he had built was a crime. Some historians who have examined the proceedings suggest that the map was kept because Elias feared his brother. That without a record of Harlan's involvement, the HC notations along the margin. The judge who had adjudicated the proceedings that gave the fraud its legal cover, Elias would have been the sole responsible party if anything had ever surfaced. The map was, in that reading, not a personal document but a mutual guarantee. If this comes apart, it comes apart for both of us. If that was the calculation, it survived both men by 7 years intact, until a school teacher pressed a spring mechanism in the dark with a mostly shuttered lantern. What do you think of this story? Do you believe everything was revealed? Or does a fraud of this scale, maintained for 40 years, leave corners that were never found? Leave your comment below. And if this kind of history moves you, the stories that happened in real courthouses to real families that almost no one remembers, subscribe to this channel. Hit the notification bell and share this video with someone who loves dark mysteries. The history that gets forgotten doesn't disappear. It waits. See you in the next one.